Good morning, Counsel, and would you help me and pronounce your name before I take a stab at it?
Meiskowitz.
Meiskowitz. Good morning, Mr. Meiskowitz, and welcome.
Thank you, Your Honor.
You may proceed.
Thank you. My name is Steve Meiskowitz. Seated at counsel table with me today is Bob Gibbons. We represent Allmerica Financial Corporation. Allmerica is asking this court to reverse a summary judgment that was entered by the Superior Court for certain underwriters at Lloyd's of London. Lloyd's issued a $10 million excess policy that follows the form of a $20 million primary liability policy.
May I ask you, when you say it follows the form, does that suggest that it agrees to the same terms as the primary coverage?
Yes, that's right, Your Honor. It follows the form of the primary policy. It has no separate insuring agreement or terms of its own. In the CNA primary policy, CNA and Allmerica agreed.
Well, let me see if I've got that then. If you have the excess insurance policy that's a follow form policy, does that mean if the primary insurer agrees to coverage that it follows that the excess insurance policy also is bound by that?
That's right, Your Honor.
Why should that be? Because the primary coverer may have made some sort of a business decision to settle, and it may have nothing to do with the policy at all. We don't know. So why should the excess be bound by that?
Well, that's not the case here, Your Honor, but there is a good faith requirement in this policy. All contracts have the covenant of good faith and fair dealing. So if CNA made a bad faith decision to pay its policy limits, sure.
But do you have any evidence of collusion or fraud?
There's none in this record, Your Honor.
You mean in the payment of the underlying?
That's correct, Your Honor.
But excuse me, even if CNA made a decision, I mean, on a business decision, bad faith, good faith, I mean, it's just a business decision that we're better off paying than going through with a trial. Why should the excess be bound by that?
Because that's what it agreed to do in its follow-form policy, Your Honor.
Well, in what way did it agree to do that?
Well, the Lloyd's policy agrees to pay upon exhaustion of the policy limits by the primary carrier. The follow-form excess carrier does not reserve to itself the right to second-guess the coverage decision, the decision by the primary carrier to pay the policy limits.
Okay, does it say in the policy that it will be bound by the decision of the primary coverer?
Your Honor, what it does is to adopt the primary policy, and then it agrees to pay upon exhaustion of the primary policy limits.
Yeah, but this seems to me to be such a basic question that I'm surprised, frankly, that it isn't covered within the terms of the policy, that somewhere in the policy itself it doesn't say we either will or will not pay depending on the situation in which the primary carrier pays.
Your Honor, in the industry, this is just so well accepted. When you read the leading commentators, they all say that the follow-form excess carrier is tied at the hip, if you will, to the decisions made in good faith by the primary carrier.
What's wrong with the judge's analysis that says holding the syndicate to the decision made by the primary carrier goes against rules of settlement, arbitration, and issue preclusion?
Your Honor, issue preclusion was not raised as an issue below, and we don't think those principles apply here. There's something else going on, and that is...
Not argued at all? The judge just kind of made it all up? Issue preclusion?
That's right, Your Honor. It was not argued in the court below. So...
But even if it isn't issue preclusion, it's Lloyd's or the underwriters had no part in that decision. And it seems very strange to bind them to it without something specific in the policy that they will be so bound.
Your Honor, if Lloyd's had wanted to reserve that to itself, again, it could have put that in its policy. But I can assure you that a policyholder looking for a stack of coverage where each higher layer exactly follows the terms of the primary policy, a policyholder in that position would not accept a follow-form policy under those conditions.
What are the exact words of the follow-form provision?
It says the underwriter's liability to pay under this policy shall attach only when the underlying insurers shall have paid or have been held liable to pay the full amount of the underlying limits.
And that's what happened here. CNA said, we're going to pay the full amount of the $20 million.
That's right, Your Honor. CNA decided to wait for the individualized relief process to run its course. CNA concluded that that was the best way to determine what the allegations against Allmerica were. 2 years into that process, CNA saw what the claims by the individual class members were, and CNA decided that the claims were covered because they were claims directed against the individual sales agents, not against Allmerica, and CNA paid its policy limits.
But what I don't understand here is this, that in the settlement between CNA and Allmerica, CNA specifically did not agree that there was coverage. I mean, it didn't agree there was coverage at all. It simply waived the defenses, presumably.
Well, there was a standard no admissions of liability clause that we all see in these agreements, but the key parts of that agreement are that Allmerica gave CNA a release, and CNA agreed to pay its policy limits.
Sure.
I understand that.
Mr. Meisler, let me ask you this. We're talking about a multi-trillion-dollar industry here, excess policies. What is the foremost case that supports the syndicate that says that when there's been a payment of the full amount and with the primary coverage is exhausted, an excess carrier can challenge whether or not there's liability?
Your Honor, we don't think there are cases that support the...
How long have we had excess coverage around?
I'm sorry, Your Honor.
How long have we had excess coverage around?
I think about 70 years, Your Honor.
Right, okay.
So there's no case. Now, but don't you have to look at this policy as a whole?
Absolutely.
Okay. So you look at the exclusions. Now, maybe you're going to talk about those a little bit later, but at least the judge says, and at first blush, well, his analysis seems fairly persuasive, that the exclusions take care of this problem. So if the exclusions are operative, how can this follow form be so rigid? Are you following me here?
I am. And by exclusions, I assume we're talking about the exclusions in the CNA policy because there were only a couple of immaterial exclusions involving nuclear hazards in the
the exclusions he talks about in his
CNA
decision.
policy.
That's the CNA
Right.
policy.
Well, there was one exclusion on which the court granted summary judgment to Lloyd's, and that was the exclusion for interrelated wrongful acts. There was a lawsuit by Mr. Jowers filed 5 years before the Bus E class action by an individual in Alabama who was not a member of the Bus E class, who used a different sales agent than the sales agents who were implicated by the Bus E class, and who was involved in a different transaction.
And notice was given to the carriers.
Exactly. This was fully disclosed to the carriers.
So
Yet-
you have to get us to reverse Judge Agnes, the motion judge, virtually on 3 different issues before you can win. Am I right?
I look at it just a little different, Your Honor. We can win either on the follow form issue, or if we don't win on that issue, we can win on the issue of whether the summary judgment was properly granted on the basis of the
To answer
exclusion.
Justice
But he-
Blaney's question, we really, if your position on the follow form issue is correct, you don't get to the exclusions, because whether or not the exclusions were valid, your position is the excess payment of the excess is triggered when there has been payment in the full amount of the underlying coverage, and not whether or not there was a valid defense. It could have been those exclusions. It could have been for any other number of reasons.
That's exactly right, Your Honor.
Okay.
If we win on the follow form issue, you don't reach the
Right.
exclusions or the known
But
loss
if you lose
doctrine.
on follow
But if we
form, then
lose-
you've got to win on both the others.
And
Okay,
then we need to win on exclusion,
Okay,
the
thank you.
interrelated wrongful acts exclusion and the known loss doctrine. That's correct.
So in other words, the excess carrier not only has the risk that liability will exceed the primary coverage, but also carries the risk that the primary carrier will waive all defenses.
Or perhaps even make a mistake. As long as the primary carrier acts in good faith, is not colluding with the policyholder.
There's no suggestion in this record that there was anything other than good faith, correct?
None whatsoever. And if you read the correspondence in the record, that becomes very clear.
But why doesn't the good faith also extend to certain underwriters? Wasn't there a requirement of good faith that they either acknowledge responsibility under their policy and pay pursuant to the terms of the policy, or make the business decision that we're just not going to incur the costs of defense on this, because those costs could create other problems for us. Why isn't what they did in settling the case a preservation of certain underwriters' position?
Talking about the underwriters
Yeah.
now? Well, the underwriters in correspondence indicated that they thought they would make an indemnity payment. There was also some good lawyerly language in that letter, and ultimately the underwriters decided to disclaim coverage, even though CNA agreed to pay its $20 million policy.
But they didn't agree that there was liability.
What they said was that they expected to make an indemnity payment, and then they changed their position. We're not raising that issue on appeal.
Mr. Meislowitz, and I will ask Mr. Smith the same thing. When you said, as far as you know, there was no governing authority for this position, has the issue been raised and dealt with?
Not head-on, Your Honor. We cite cases in our brief
I know,
that
yeah.
come very close. But I think the issue has not been dealt with squarely, except in the commentators. They do talk about it.
No.
But I think it doesn't come up because it's just so well accepted in the industry. Policyholders have this expectation, and most follow-form carriers honor it.
Have you cited the commentators?
Yes.
Yes, we have. And they're also cited in the amicus briefs.
And they all take that position that you're espousing today?
I'm not
That
aware of it.
if a primary in good faith does what the primary did here, the follow form is stuck?
They say that what the follow-form carrier does is to agree to pay upon exhaustion of the primary limits. And as long as that exhaustion is in good faith, the follow-form excess carrier is not free to question how aggressive the primary carrier chose to be with respect to coverage.
Did the syndicates or the excess folks have notice that these discussions and all this stuff was going on?
Yes, Your Honor. All-America actually traveled to London
And told
before the first policy and before the renewal policy and discussed with
The Busey
Lloyd's
case with them?
exactly what was going on. The Busey case had not been filed.
The other one? Which one?
The Jowers case. The
Jowers
Jowers case
case.
was disclosed in the application that was given to both CNA and to Lloyd's.
My memory is a little hazy, but aren't you required to give notice, once you've got a claim, no matter how many layers up you go, you just give notice all the way up?
And that was done.
Yeah, that whether or not the contracts require that, that's usually best practice, you would do that.
Was the
It may be that there's a layer so high that there's no reasonable possibility that coverage will extend that high, but that's not our case.
Maybe I've got my facts a little bit mixed up, but once they got the insurance in place, the Busey case occurred. Am I right?
After the insurance was in place, then the Busey case was filed.
Correct. Now, as they're proceeding along with CNA and Busey and all that kind of stuff, were they telling the syndicates, this is what we're doing? You folks better be on your toes because your policy might be implicated?
Well, notice was given to Lloyd's of the Busey case. Lloyd's monitored the Busey case. And
After
that's
the
clear from
policy
record.
was enforced, was that before or after the policy was enforced?
Well, the policy went in, there was an original policy that
Right.
went into effect in 1996. That was renewed as of July 1st, 1997. Busey was filed late in July of 1997 in Louisiana. It was dismissed and refiled in October of 1997 in the Superior Court here.
When you say that this practice is well settled in the insurance industry, that the excess is bound by the primary settling in good faith, was that all brought to the attention of the judge below?
Your Honor, I think that the argument was not as well developed, but the follow-form argument, if you will, absolutely was made in the Superior Court.
But he wasn't made, I think he mentioned, if I'm thinking of the right case, that he mentioned that this was an issue of first impression in Massachusetts, which it is. But I don't recall any mention in his decision that it was well settled in your favor in the literature.
I don't think that was that argument. I don't think we argued the point in such detail in the Superior Court.
Does the literature take into consideration the kind of a settlement that occurred in this case, where there is an express disavowal of liability? Isn't that unusual?
No.
Well, I would say yes, because what the commentators say is that it's the exhaustion as opposed to the acknowledgement of coverage. It's the
But
good
a,
faith
but a
exhaustion.
standard release order says without admitting to liability. I mean, that's not unusual.
That's right.
I mean, I don't know what you were answering, no or yes to Justice Spina, but in standard, I mean, standard primary coverage and all kinds of other coverage as well, there's a dispute as to coverage, right? I mean, otherwise if there's no dispute, there's no litigation. So if there's a dispute as to coverage, and the absolutely standard release is no liability, but we're paying.
That's correct,
For
Your
all
Honor.
kinds of reasons. For all kinds of reasons that may have to do with, consequences.
That's particularly true in a class action, too.
May I ask you another question? Really going to 3G, the exclusion in 3G. I mean, it seems to me that the whole thrust of this complaint is that the All-America itself sort of masterminded a scheme to misrepresent the value of its policies. And if that is in fact the cause of action, the allegation, I mean, that's clearly not covered. That's clearly excluded under 3G.
Well, that's one of the key points of our position, Your Honor. This is an indemnity policy. This policy does not contain a duty to defend. The duty to defend is determined by the allegations in the underlying complaint. The duty to indemnify is determined by the facts, as best they can be determined where a case settles. And here, it's the statements by the class members during the individualized relief process that provide the best evidence of the facts. And almost to a person, those class members identified the sales agents, and not All-America, as having made the misrepresentations they were complaining about.
Were those sales agents located in one sales marketing area?
I think they were spread over
Right
a number
across
of
the country.
states.
But I mean, were they right across wherever All-America did business? Sold policies?
Yes, I don't think they were confined to particular jurisdictions.
Well, wouldn't it be reasonable to conclude from that in fact it was an All-America tactic, not an individual sales agent tactic?
Not at all, Your Honor. First of all, based on the statements in the individualized relief files, based on the fact that almost no class members alleged that All-America made misrepresentations, based on the fact that the plaintiff's lawyers stipulated that if a class member's file contained written materials from All-America, that was evidence that no misrepresentation had been made. In other words, they were persuaded in discovery that All-America's statements and its written materials, and that's the only way All-America communicates with policyholders, that they were accurate.
I think you misinterpreted the Chief Justice's prior question. Were the agents like in an All-America office, or right across the street from an All-America office? The agents
the
who made-
employees or independent
That
agents?
was the question, not
I'm sorry.
across
Yes,
the
they were
country.
independent agents, and they were spread across the country.
Okay. Thank you, Mr. Meisterowitz.
Thank you, Your Honor.
Mr. Smith, good morning and welcome.
Good morning. Thank you, Your Honor. Let me address a couple of points, I think some questions that you raised. First of all, there isn't a lot of case law on this point, and I think the reasoning is clear. What All-America and the amicus...
Is there any
parties-
case law? Is there any
There
case-
is. There's a few, and I can cite to you the cases we have in our briefs,
Right, okay.
the Revco case
But
and the Allstate case.
Directly deal with this issue.
No, and I think they talk about an excess being able to still contest coverage if the primary agrees to coverage and pays the loss. But the issue here is the radical rule that All-America and the excess or the amicus are presenting to you is that this shouldn't be a follow the form policy. This should be a follow the settlements policy.
Well,
But
is the literature...
either way,
is-
it's radical, correct? I mean,
There's recognition.
surely if there was a follow the settlement, I mean, I'm really trying to understand. We can agree, can we not, that there are endless settlements, correct?
Sure.
Somebody looks at it, they make a good faith judgment. I don't know too many insurers that just willingly pay, but they make a good, as Justice Counsel, it's a good faith business decision for whatever reason. They're worried about getting an interpretation that might be a negative interpretation from a court. They're worried about, resource allocation, all those kinds of things. So reaching to excess coverage is not unusual, right?
That's true. That's true.
And And not infrequently, I mean, on a fairly regular basis, the underlying settlement, if there's been a settlement, often disclaims liability,
That's true.
right? So the fact that, and one would expect that if an excess carrier said, no, this just follows form and we can make an independent determination, wouldn't you expect to see lots of litigation about that?
No.
Why?
I don't think you do, and that's because the
Okay.
concept in the insurance world of follow the settlements is a reinsurance concept.
Okay.
In the reinsurance world, reinsurers and insurance companies have a contract. In that contract, there's a follow the settlements provision. You see a ton of arbitration in the reinsurance world about follow the settlements and how far that goes. But that's reinsurance.
Yeah, but this is
That's-
excess, and excess, at least as I read at least one reading, I shouldn't say I read, one reading is when the policy, or the underlying, the primary, when the policy limits have been reached, that triggers payment.
It does, and the distinction that you want to look at here is looking at the merits of the underlying claim versus the coverage. There's a big distinction.
of course there is.
If the underlying carrier decides that it's going to settle a case or pay defense costs that exhaust the limit, and they think that those defense costs are reasonable, and now it exhausts and goes up to the excess carrier, and it's clearly covered, and the excess carrier says, well, I disagree with you, or I disagree with you because you guys are wimps. You should have tried this case instead of settling it, because you could have won on the merits. That's the kind of good faith that the excess carrier is not able to fight.
I mean, I have some trouble with that, because if there's an applied good faith, and unless you can show there was bad faith, I mean, here there's no claim of bad faith. So the question is, who has the burden? I mean, you say it's radical, they say it'll wreak havoc. And just before I become a radical or wreak havoc, I'd like to know which way I'm wreaking the radical havoc here.
Well, do you disagree with Mr. Myslovich's statement that the literature is that this is well settled in the industry and that the excess is bound by the primary settlement?
Absolutely. I think if
You
you look,
agree with him?
No, I disagree with him.
Well, is the literature contrary to what he says?
I think that the cases are clearly contrary to what he says.
You just told us
I
there
think
weren't
that
cases. You just told us, I thought, that there are no cases that deal directly with this issue.
Well, what you're going to find is that even in most of the commentators, there's no discussion of this issue.
Well,
And-
because it's assumed one way or the other. I mean, I've looked at some of the treatises, and one, I mean, I don't think, certainly Mr. Meislowitz is not misrepresenting what they say, and they say, when the policy limit is reached, then you go to the excess carrier, and I think both of you could say, yes, but that doesn't address this issue, correct?
I think that's exactly right. I think it doesn't address
But
this issue.
doesn't the follow the form policy incorporate the terms from the primary policy?
Absolutely, and the reason for that is that if you had a primary policy with certain language and the excess created its
You
own
can't.
language,
You can't.
it wouldn't be
You can't.
uniform.
You have
You've got to
essentially-
have the same language. And so the question here is you had a primary carrier who reserved rights and an excess carrier that reserved rights, both of them on the same basis. Both of the carriers came into this and said this thing is not covered. And so ultimately, CNA made, from our perspective, a business decision to settle a loss.
Yeah, sure.
Not that it was covered, but they made a business decision.
They were perfectly entitled to do that.
And they can certainly do that, but that business decision
can't-
doesn't bind the excess
I
carrier.
can't imagine. I mean, I'm thinking, for example, in another context, and maybe it's so different I shouldn't do it, but think of all the pollution exclusion stuff after CERCLA, when nobody thought that what the underlying policy covered was all of this leaching into the ground, which wasn't even a violation of the law at the time. First people challenged it, and after a while they started to be settlements. Are you telling me that the excess people didn't challenge that? Nobody challenged it? I mean, in other words, once the primary insurers started paying, which were really business decisions.
For the sites, the
Yeah.
losses at the site?
Yeah.
Well, I think they did challenge that. I think that what happens is...
You know what happened. The primary coverage was like 100,000,
Right.
and the liability was $4 billion.
Right, and the
Right.
primary settles, and the excess then has the coverage issue.
And you're telling me they didn't challenge? And
They do. What I'm telling you is
Where are
that
the
there
cases?
these-
Because don't the cases reach this issue then?
There are cases where excess carriers dispute coverage. In those cases, it's not raised. The issue here isn't raised. The issue isn't raised that, oh, well, the primary settled, so now you're bound by their settlement. That hasn't been raised.
And that issue, again, I say the same thing that I said to the other counsel. I don't understand why this isn't covered in your contract. It just seems to me such an obvious question that people who deal with insurance every day would see that the underlying is going to settle, and then what are we going to do?
It's not covered in the contract. He says you folks knew what was going on. You were told about the Busey case. Your policy is in place. That should have raised some red flags over wherever you folks are, saying, well, they might settle this thing.
Well, it did, Your Honor, and we did reserve rights. We did ask for information. We were getting some of the information in the case. But it was clear to us, and I think when you sit down with the record in this case, it'll be clear to you that this was, as Justice Cordy said, this was a sales practices case against All America. There's no question about that. That's what they settled. That's completely excluded. The record doesn't support
this benign approach that it was the agents are off on a frolic isn't supported by the record, is it?
No.
Because, that would be astounding if All America somehow can build a wall of, between it and its agents.
Well, I
not know this was going on.
Well, the more important issue for this court, I think, is the fact that in the Busey case, All America went to the federal court and said to them, this is All America's scheme. We did this. They agreed with the plaintiffs. And why did they do that? They wanted class treatment. They wanted a class action certification to bar the 3,000 policyholders that had claims out there. They did that in the federal court. They now come before this court and say, no. This isn't the class action. This is individual agents. Judicial estoppel prevents that.
Well, that's assuming we get to the exclusions. Let me just think of it from my point of view. I have, I'm just a little, I want coverage. And so I get, my primary, and then, my good agent says to me, that's probably not enough, so you better get some excess. And he says, look, it's fine. It's all, it's just a question of who pays. So I, litigate like crazy. My primary insurer says, no, and I'm forced to expend fees and so on and so forth. And finally we settle. And I think, well, that's fine. Now I've got the thing resolved. And you're saying to me, all the way up the chain, I've got to go battle it again and again and again.
I don't think so, Your Honor. You don't have to fashion that rule in this case. Here's why.
Okay.
When there's a claim that approaches those excess layers, the Superior Court ought to be saying to the primary and the insured who are litigating that issue, those fellas up there, those companies up there are indispensable parties to this coverage litigation, first of all.
So since when does the court decide who the parties are?
Well, if the excess carrier is potentially going to be hit with that settlement or with that amount of money, it needs to be in that underlying case. Secondly, you could fashion a rule. Maybe in another case it's not here, but you don't need to go for each layer.
You had notice of this underlying lawsuit, I assume.
We did.
If you thought you were an indispensable party, there were mechanisms available. There were mechanisms available to you.
Of course, and we reserved our rights and said there was no coverage from the very beginning with the insured. And as Mr. Meislowitz said, this is an indemnity policy. There's no reason for us to defend or do anything until the loss is over and they present the loss and we see if it's indemnifiable. This loss was not covered.
So you'd cover a judgment in this case if it went to judgment?
We may.
As opposed to a settlement?
Well, it depends upon whether it was covered or not. If there was coverage litigation between the primary and the insured, that may create a res judicata collateral estoppel issue on us.
It may not, because they may be fighting over, one exclusion and nobody paid any attention to the other exclusion because somebody made a good faith judgment the other exclusion didn't apply. You get a judgment. Mm-hmm. and then the excess carrier comes in and says, oh, but you've overlooked, exclusion 3G.
And I think those are all interesting issues, but they're not the case here. This is just a business decision made by an insurance company, and as far as Judge Agnes was concerned, it was the wrong decision on coverage, and now they want to bind us to this wrong decision.
Mr. Smith, let me ask you this. What you're saying basically is that the excess policy is not automatic, right?
True.
And I understood your brother to say they're joined at the hip. I think he used that expression. You get the excess policy. From the consumer's perspective, if you have insurance coverage, primary policy, and also an excess policy, shouldn't you be able to assume that it's automatic?
Let's take this case. If you're the insured in this case and you're told in both policies you're not going to have coverage for sales practices, vanishing premium claims, there's no coverage for that. You go out with your primary and cut a deal, and the primary pays on a vanished premium case. You then say, I want to now bind my excess carrier to that decision so they pay this loss, which isn't covered. I don't think you really would believe that as an insured, yet that's what we have here.
But
That's the situation.
the insured would change his decision on whether to settle, I think, based on whether or not the excess were going to be bound. Wouldn't that impact his decision?
Oh, the excess carrier reserved rights.
Right, anyway.
Right.
Yeah. All right.
I mean, they knew that we reserved rights. They
As
knew
you-
that we had done that.
Would it have been possible to bring, for All America to bring you in the underlying litigation? You can add anybody, correct?
I don't think that insurance companies can be brought into the, you're talking about the Busey
Class
case?
action?
No, I'm talking about the coverage. Wasn't there?
Oh, sure, they could have. They did sue us. After they settled with All America, they sued underwriters and said, you owe us coverage. And we said, take a look at your exclusions that apply to this case. We don't owe coverage. And so we did that case, and Judge Agnes looked at the record and found that the known loss doctrine applied and that the prior claims exclusion applied.
A little further back, they could have filed a declaratory judgment action, probably.
Underwriters?
Yes. The underwriters or All America or CNA, one of them, saying, or all of them, saying, give us some guidance on if we settle this, and based on the language in the CNA policy, which appears to set up an exclusion, whether the excess carriers are going to be liable.
Well, they could have. I mean, in essence, they ultimately did. And part of the issue is when do you file that declaratory judgment as an excess carrier? If this loss was within $20 million and didn't exceed $20 million.
I'm talking about filing it before it got to the state where everybody's locked in like they are now. That's what declaratory judgments are for.
That could have been done.
But anyway, we got to deal with it the way it is.
Mr. Smith, could I ask you this?
Sure.
I don't know whether you've had an opportunity to read the amicus briefs. We have, but one of the claims, one of the briefs, which addresses the exclusion, at least with respect to the known loss doctrine, points out that this is a common law doctrine and there are other better mechanisms to deal with this, namely the bad faith, that kind of thing. In other words, the claim is that it's clear that your clients knew about the J case. I always forget. Jowers. And issued the policy notwithstanding that. And the argument is made is that it should be narrowly construed, the known loss document. Otherwise, you're really putting at risk a lot of coverage.
Well, I think the answer to the question, and it's an important one to recognize, that Jowers was not the only record evidence in this case of prior claims or knowledge by All America.
Okay.
There's 100 pages in the appendix we gave you of other claims that were made. Some they settled, and some of those claims went on to be Bussey class members. So the fact of prior claims exclusion just being Jowers isn't the case. It was the entirety of all of those claims, Jowers, and the atmosphere of litigation at the time with all of these class actions filed for vanishing premium claims. All of that gave them the knowledge that would support the known loss doctrine, as well as the prior claims exclusion.
May I ask you one more question, please?
Yes. Yes.
You refer to CNA's decision to settle as a business decision, as if somehow that's unrelated to an assessment of the risks, which everyone does when they determine whether to settle a case of this. Or why is this so different than any other rational decision that's made in the context of an insurer deciding whether to settle a case?
Well, because insurance companies also often settle cases sometimes when they're not covered because they have a long relationship with that other
But there's a lot of
insured.
didn't they pay $20 million in this?
Sure.
case? So it's not just, well, we'll pay a few pennies here and preserve a relationship.
But let me give you another thought here. CNA not only issued this policy to All America, they issued a policy that covered All America's agents. That policy had a $50 million aggregate limit. That policy insured All America for its vicarious liability for acts of the agents. And what counsel says is that, well, it only covered defense costs, but it didn't. It covered defense costs and expenses. You add up the defense costs and the expenses in the All America case, it's $27.5 million. They had every reason to say, let's not put it on the agent policy, let's put it on the other one.
Is this developed in the record? Because this sounds like bad faith.
No, it's not.
Oh.
This is not developed in the record, other than to say that the policies themselves are there for you to look at.
But that may not be bad faith. In other words, somebody can settle on one, that's also a business decision.
In the insurance industry, we call that adverse selection. You'd select one policy versus another because it's a better
Who's the excess
deal.
carrier on the other side? Who's the excess carrier on
On the agent, I'm not sure there
Not
is any.
you.
I don't know. Not on the agent policy.
Probably
I don't think.
nobody.
Thank you, Mr. Smith.
Thank you.